Good morning. My name is Grace Orsetti. I'm the director of the Wills and Healthcare Decisions Clinic at the Thomas R. Kline School of Law of Duquesne University. Welcome to this presentation on the basics of estate planning. With me are 7 law students from the Duquesne Kline Law School who are members of the Wills Clinic and who, along with the Wills Clinic, participate in drafting documents for the community, drafting estate planning documents for the community. So we're here to share a little bit of information about what estate planning is and some of the things that you should know if you're thinking about preparing an estate plan, which is something that everyone should do. The basic estate planning documents that everyone should think about having are a last will and testament, in which you decide how to distribute your property after you pass. And then 2 other very important documents that everyone should have are a healthcare power of attorney and a living will. A healthcare power of attorney allows you to appoint someone to make medical decisions, and a financial power of attorney allows you to appoint someone to make financial decisions. None of these documents are designed to take away your property or to take away your power to make decisions for yourself. It's rather the opposite. These documents are to allow you to make decisions for yourself before it's too late. They allow you to take control of your future, to take control of your decisions, and empower you to choose and make decisions about who you want in your life, who you want to be around you, who do you want helping you and supporting you in making decisions at a time when you can't make them yourself. For whatever reason, there may come a time where you might need assistance making decisions about your living arrangements, your health care, your financial matters, and you may not necessarily need a guardian. That's what we're trying to avoid, is a full guardianship. But you can choose a trusted network of supporters to help you make decisions, and you can decide what happens to your property when you pass away. You can control the level of support that you want to receive. You can put checks and balances on the people you appoint. You can appoint multiple people so that the decisions are spread around. But these documents, again, allow you to advocate for yourself, whether you need help now because of life circumstances that might be making it difficult for you to carry out your important matters, or in case you need help in the future. And again, to distribute your assets in the manner that you choose. So with that, I'm going to turn it over to our first group of students who are going to talk about a last will and testament, what that document means, and what it can do for you.
So what is a will? Very simply, a will is a legal document. It states your wishes for your property and for any minor children you have, and what happens to them after you pass away. A will allows you to name a personal representative, usually someone that you trust greatly, that will be in charge of making sure that your wishes that you set forth under your will are followed.
So who will you be naming in your will? Within your will, first, you'll be naming your personal representative. This is the person who will be taking care of your estate once you pass. Next, you'll be naming your beneficiaries, the people who will take under your will or receive under your will. Next, the guardians. If you have minor children or people who may lack capacity, you may appoint a guardian in your will to take care of those individuals once you pass. And then finally, disinherited individuals. These are people who you specifically name to not take under your will.
Why should you have a will? A will gives you the power to choose someone to manage your affairs instead of allowing your property to pass through the method that the law decides. And in Pennsylvania, that would be following Pennsylvania intestacy law. They can be customized to do what you want them to do and to fit your particular needs, devising any property you have or any special gifts you want to give to particular people. It also helps to avoid unnecessary familial confusion or arguments. If you promised to give your son a particular gift, you would want that to be listed under the will to make sure that any siblings of your son would not have a claim to the gift that you had already promised. That really helps keep families together during the really hard time.
So how does a will work? A will takes effect after you pass away. The personal representative you appoint in your will use your will to distribute your property in accordance with your wishes. The personal representative will also be responsible for paying the taxes and the debts that your estate owes out of your estate's assets.
So what will pass under your will? Under your will, you'll be passing cash, that is anything, including in your savings, your checking accounts, intangible personal property, that could be anything of value that you don't physically touch, including your stake in businesses or stocks you may own. Personal property, which is anything physical you could touch, like pieces or items that you would want to give specifically to people. And then some types of property that don't pass through the will are bank accounts, life insurance, or jointly owned property that identifies who will be taking it within those accounts.
The requirements of a valid will. A valid will can be made by someone who is 18 years or older and of sound mind. This requires that you are aware of the property that you have and who you're giving them to. A will needs to be a written document, and every will needs to be in writing and signed or marked by you. In Pennsylvania, a will does not require that it is witnessed or notarized. However, these are highly recommended.
So intestacy, what is it? Intestacy is what occurs when someone dies without a will. In the case of intestacy, state law will dictate what happens to your property and how it's distributed between your family members. Oftentimes, intestacy is not in accordance with what you may wish. So for that reason, avoiding intestacy is one of the most important reasons why you should have a will. What is electing against a will? Electing against a will is a surviving spouse's right to claim a share of the deceased spouse's property, regardless of what the will says. In Pennsylvania, for example, a surviving spouse is entitled to 1/3 of the estate. Electing against a will makes it very important to formalize divorces between separated spouses.
So what is probate? Probate is the legal process that you must go through to prove a will. Having a will not allow you to avoid probate, but can greatly benefit you in the probate process. Probate can take from 9 to 18 months, and having a self-proving will is incredibly advantageous. The self-proving will is what we talked about earlier. Having witnesses and a notary on hand will make the will self-proving and help greatly in the probate process.
We're now going to turn it over to two more students to talk about the financial power of attorney document.
Hello. So broadly, what is a financial power of attorney? It is a means to empower someone, an agent who you trust, to make financial decisions for you. And the durable nature of the authority conferred upon that agent is exercisable notwithstanding to the principal's subsequent incapacity or disability.
So how does a financial power of attorney work? There are two types of financial power of attorney. There is a general, where an individual or multiple individuals are given general authority over your financial decisions. With this type of financial power of attorney, it takes effect the moment that it's signed. And there's also a limited power of attorney, where an individual or multiple individuals are given authority over a particular transaction or for a limited duration.
So why should you have a financial power of attorney? The document gives you the power to choose someone to manage your affairs instead of having the court appoint a stranger. They can also be customized to do only what you want them to do and fit your particular needs. And most importantly, it avoids unnecessary court proceedings and cost.
So there's also a springing power of attorney in case you don't want it to become effective immediately. A springing power of attorney is a financial power of attorney that only comes effective once a specified event has occurred and can be limited in their scope for something like capacity or incapacity or traveling abroad. For example, if you have Alzheimer's or if you've been around somebody who has Alzheimer's, you know that there are gray areas where people can have good days or bad days and capacity can be sort of unknown day to day. So there are disadvantages to a springing power, financial power of attorney, but in general, they are an option for you if you'd like one.
So who should you be your financial power of attorney? So when choosing a financial power of attorney, you want to make sure that they are someone that you trust completely, preferably someone who has experience managing finances, or someone who has demonstrated the ability to be financially responsible, or preferably someone that lives relatively close to you and is available at a moment's notice.
So what terminates a financial power of attorney? A financial power of attorney can end for several reasons. When the principal revokes the agreement or becomes deceased, when a court invalidates it, when the agent can no longer carry out the responsibilities that were outlined within it, and in the case of a married couple, the authorization may be invalidated if the principal and the agent divorce.
And we're now finally going to turn it over to two more students to talk about the healthcare power of attorney and the living will.
Yeah, so now we're going to talk about The healthcare power of attorney. So what is a healthcare power of attorney? It's a document that allows a patient to select someone, an agent, to make healthcare decisions on their behalf. And this person will make the medical decisions for you if and when you become unable to do so yourself. It takes effect when the principal, which is you, becomes incapacitated. And the principal can include guidance or goals to help the agent make decisions.
So picking an agent is the person that's going to be making these healthcare decisions for the person. It should be a responsible adult who you trust greatly, as they will be making the medical decisions for you. It really should be someone who lives close by, so if there's ever an emergency, they can be there to help start making those decisions immediately. You can appoint one agent or appoint multiple agents. If you appoint multiple agents, you can have it so that they have to agree on every decision whenever they're made. Or if the agents cannot agree on a decision, one person's decision will take priority over the other. It's also best to appoint a backup agent. So if the agent you've appointed cannot do so or is not willing to make the decisions necessary, there's a backup that can do it in their place. Any medical decision that the principal cannot make on their own is something that the agent can do for them. This can take place after the person making the power of attorney has been under general anesthesia. If they cannot communicate because maybe they had a stroke or they're unconscious or in a coma, or maybe they have a disease such as dementia in which they cannot make their own healthcare decisions to the best of their ability. These decisions can include end-of-life decisions and also organ donation if it's not specified.
So why have a healthcare power of attorney? It reduces the chance that a court proceeding will be necessary under Pennsylvania's guardianship laws to appoint a guardian of your person to make decisions about your care. So it ultimately just gives you the power to make that decision instead of the court. So also a living will. A living will is a document that instructs and guides your doctors and your healthcare agent as to what medical care you want or do not want. And this document does not include or predict all possible medical situations and potential outcomes, as an individual's medical circumstances are subject to change.
And that concludes our presentation. We're available at the Duquesne Kline School of Law if you have any questions, and our information will be posted on the website separately. Thank you.